like 3 weeks ago, I saw a very interesting Russian court ruling that's again linked to Google case. And Russian subsidiary of Google went bankrupt, and its manager now acting on behalf of Google. And the manager brought several claims to challenge Google transactions. And so these proceedings are within the bankruptcy framework, not Lugovoy Law. And so I pass the floor to Nikolai to view this situation from bankruptcy proceedings. So if the threat is even higher.
In brief, yes, indeed, it's definitely higher. And I will divide two situations, the insolvency of the Russian subsidiary of the foreign company and insolvency of the foreign company itself in Russia. The first case is quite well predicted and well expected by the foreign companies having such subsidiaries in Russia, since for the previous years, most of them made significant steps to stop any business activity in Russia, and eventually it should lead to insolvency of these entities. So I will not pay too much attention to the insolvency of Russian subsidiaries, but I will highlight just 2 points in this respect. First of all, we should not expect that the consequences of such subsidiary insolvency would relate to Russia only. So it's quite acceptable for the many of the foreign companies that their Russian assets and assets of their Russian companies will be distributed between the creditors, but it's not the end of the story, because the second stage of this story is the recognition and enforcement of the judgment from the Russian insolvency proceedings abroad. And those judgments may be issued not against the Russian subsidiary itself. It may be issued against the counterparties, against the management, against beneficiaries, shareholders of the Russian subsidiary. And those judgments may be enforced abroad, like Google case, where in October the judgment on dividend payment challenge were recognized in the amount of $120 million. So it's the scope of consequences of the Russian subsidiary insolvency is not the Russia only. It may be enforced abroad. And the second trend nowadays is attempts of the Russian receiver of Russian subsidiaries to challenge transactions with the management and employees of the debtors. And we see that a lot of foreign companies, I will say, try to protect their former employees and their management, not only because of the ethical considerations, but because of the, I will say, significant value of the staff for the evidence and further development of insolvency proceedings. So, talking about the less expected topic about insolvency of the foreign companies themselves in Russia, I will just say about 3 main things. First of all, insolvency of the UAE or European or US company in Russia is a kind of lottery. However, you may affect the outcome of a draw. What do I mean? A lot of foreign companies has already bought a ticket for this lottery, because the test for introduction of the secondary insolvency proceedings is very broad. I will say that the primary insolvency proceedings are possible as well in case no defenses were provided by the foreign debtor in Russia. But the most likely outcome is introduction of the secondary insolvency proceedings. The problem is that there is no any statutory or codified law in this respect. There is no detailed and verified test for introduction of the secondary proceedings. So this mechanism, I will say, appeared just less than 2 years ago. It was 8 February of 2024 when the Supreme Court issued the ruling on a Westwall case. So basically the whole option of recognition of the foreign company insolvent in Russia is based on one High Court ruling, which means that the test mentioned in this ruling is quite broad, and there are different examples of what may be considered by the Russian courts as close connection to Russia and be a ground for secondary insolvency proceedings. Just for example, if the company performs an economic activity in Russia, what does it mean, economic activity? It's a very good question for dispute. If the commercial activity of the company is aimed at Russian residents, it's maybe company located abroad, for example, IT company, but its activities is aimed inter alia to Russian residents, and this may be a ground for the secondary insolvency proceedings. If the company has a managing body or a branch in Russia, if the company owns property in Russia, including the property rights. So we are not saying that the movables or shares should be held. It's fine to have just the right of claim to the debtor in Russia, and this may be a sufficient ground to start the insolvency proceedings. So in practice, we see that there are several hundreds cases initiated for the last 2 years for insolvency of foreign companies in Russia. More than half of these cases were initiated by the Russian tax authority. So the state is practicing, the state is testing this mechanism. The state is checking what is possible within this mechanism. And we see that the court generally tend to introduce and to satisfy such motions. Sometimes the only connection, as I mentioned, is just the right of claim of the foreign company to the Russian debtor for a considerably small amount, and it was sufficient to recognize the company insolvent. I will especially note that the Supreme Court highlighted that the burden of proof is mainly on the debtor in such cases. So it's fine for the claimant to generally show that there is somehow connection between the debtor and between the claimant, between the debtor and Russia, and it's the debtor's burden to provide the full proof of the absence of such connection. So a lot of foreign companies ignored such Russian proceedings. Most of them didn't even know about the start of such proceedings, which was sufficient for the Russian court to say that no, any objections were provided. Notification, as Igor mentioned today, is not a strong part of the Russian legal system, I would say. And most of these companies were not notified about those proceedings. Also, we calculated that in 75% of cases, there were no public announcement about the start of insolvency proceedings. So there is a court database, and you should carefully check whether there is a line about filing of the motion. And what does it mean? It means that in case the foreign company missed opportunity to present the defense, then most likely the court will apply at least secondary insolvency proceedings. However, we see the examples when the foreign company is successfully defended. For example, Credit Suisse, which actually has quite significant assets for billion rubles in Russia, successfully protected itself from starting of the secondary proceedings because of the active and good presentation of arguments. So this is a lottery, and you may miss the draw in this lottery. But if you present your position, it's quite possible to protect yourself from the Russian insolvency. So this was the first point. The second point, that insolvency in Russia may start sooner than you expected, because by default, you may expect that insolvency proceedings will start after the long litigation proceedings on recovery from the foreign company. So the creditor will get the judgment on recovery, and only then the creditor will start insolvency proceedings on the basis of this judgment. It's not true. Or it's not an absolute true. Thus, if the creditor or the foreign debtor is a Russian bank, or the creditor of the foreign debtor is the Russian tax authority, then those bodies, under some conditions, may start insolvency proceedings without getting the prior recovery judgment. So you may just have an obligation before the Russian bank out of credit agreement or before the tax authority, and there will be no any pretrial procedure in this respect, no any litigation on recovery of money from the debtor, they are allowed to start insolvency proceedings as a first step of the activity against the debtor. And this is quite a big issue. We see that this trend is just appearing. We found one case when this was accepted by the court. We found one case when the court dismissed these arguments, but at least this is a quite significant risk that banks or tax authority will start instead proceedings without any preparation steps in this respect. And what does it mean? It means that the foreign debtor will not have enough time to collect information and present good, well-grounded position to object introduction of the secondary insolvency proceedings, because it's quite short period, 1 month, usually 1 month, between appointment of the hearing and consideration of this issue. So from the practical perspective, if you have a creditor like a Russian bank or a Russian tax authority, I will strongly recommend to collect the evidence and arguments objecting the grounds to start insolvency proceedings in advance, not waiting for the filing of the motion. And the third last point in this respect is that, once again, consequences of the Russian insolvency proceedings are not limited by the territory of Russia, even in case of the secondary insolvency proceedings. I understand the concept that primary proceedings are usually considered as worldwide effective, while the secondary insolvency proceedings are usually associated with the effect only within the territory of the secondary insolvency proceedings. But in fact, when we're talking about Russian secondary insolvency proceedings, it's quite possible that the judgment on challenging of transactions may be recognized abroad. We talked about it earlier. And also the damages tort claim against the management and shareholders may be recognized abroad as well. And there are two issues in this respect. When we're talking about challenging of transactions, we should understand that in Russian insolvency cases, those not only the contracts, the performance of the transactions may be considered and challenged as well. For example, the payment under the contract may be itself considered as a transaction. Economical consequences of this transaction may be assessed, and this payment may be challenged, like payment of dividends in the particular Google case. And the second point is that the tort liability damages for the management and shareholders for insolvency of the foreign company is quite not, I will say, not discovered area of current Russian case law, because there are just first motions filed in this respect in several cases, and there is no exact test. But we expect that the companies who left Russia intentionally, and most of the Western company, of course, made some decisions in this respect. They made some announcements in this respect. Most of them clearly tried to withdraw itself in assets from Russia. So these steps aimed at stopping economical activities in Russia may be considered as actions which actually led to insolvency of the company, insolvency of its property estate in Russia, which is quite a big risk. The problem with those insolvency judgments is that they are based on a, I would say, natural jurisdiction for the insolvency cases. Because when we're talking about Lugovoy Law, it's quite clear that there is a direct breach of the DR clause, arbitration agreement or prorogation agreement, by the very specific and politically affected Lugovoy Law and attempts of the Russian claimants to rely on this. But when we're talking about the insolvency, the problem is that generally the insolvency is a natural way to bypass the arbitration agreement. In the most countries in the world, it's quite direct rules that arbitration agreements, prorogation agreements may be ignored in case of insolvency, because the claims should be considered all together in the same case, and it's quite normal. So the same creditor, which initially had to file the claim under the Lugovoy Law in order to go to Russian court, he may avoid this and file the claim on the basis of the insolvency rules. And in such a case, it will be not a ground as a politically affected Lugovoy Law. It will be normal, recognized all over the world ground like an insolvency proceeding, secondary insolvency proceeding. So this may be considered as another way to avoid the risk with recognition of such judgments abroad. And another risk which is not discussed yet, and generally I didn't hear about this at this conference, maybe I missed it, is that even the receiver appointed in the secondary insolvency proceedings may try to claim some rights for the assets outside of Russia. Formally, of course, his rights relate to the assets within the territory of Russia only. But he may argue that some particular assets were transferred from Russia outside, and those assets initially were aimed to be used for satisfaction of the foreign company within Russia, and that's why the receiver has a right to come, for example, here in UAE and say that, look, those assets are located here, but actually those are Russian assets, and that's why I have some powers over those assets, and then file the respective claim for foreclosure or similar claims. So what I'm trying to say that, first of all, that the threat is quite real. Second, you should be prepared in advance, because it's quite possible that you will not have enough time to present the position when it starts going. And the third point is that it will be really nice to consider in what particular jurisdictions the judgment will be potentially recognized, in order to assess the local rules on recognition and to assess what kind of defenses should be presented before the Russian court in order to prevent the potential subsequent recognition abroad.
Thank you. So, Igor, so what do you think about the topic Nikolai mentioned, like insolvency cases, and so any impacts for this jurisdiction?
Well, this jurisdiction will definitely have some traction with that. Again, we need to look at it from the perspective of both offshore and international courts here, onshore and international courts here, because the situation will be very different. Also, speaking about an onshore courts, fortunately or unfortunately, depending on whom you are representing, there will be very, I would say, little room for enforcing Russian insolvency judges in onshore courts, because here there will be an additional complicating element, very technical one. It will be the same requirement for reciprocity, but in that particular case, the reciprocity should concern specifically the enforcement of insolvency judgments and not general civil judgments. They've been a reported case of a Dubai Cassation Court, which I think judgment was delivered about a year ago, which confirmed that position in onshore courts. I'm not personally aware of any UAE insolvency judgments being enforced in Russia, so it will be very difficult to prove reciprocity here. And unfortunately, if you can't do that, that's where your discussion with onshore courts end. However, if we speak about courts in DAFC, the situation will be different. Because DIFC insolvency law is very different from the insolvency law, onshore insolvency law. And speaking about the cooperation with foreign courts, DIFC specifically adopted the ancestral model law on insolvency. So those who practice international insolvency are surely familiar with that. So it's being adopted in its entirety. So it's just the same rules. That's why on the other hand, you at least have an instrument how to do that. Second, speaking about like foreign companies registered in DAFC, if they're registered as branches of respective foreign companies, as a matter of DAFC corporate law, they are deemed to be recognized foreign companies. And as a matter of DAFC insolvency law, you may start an insolvency of a recognized foreign company in DAFC. So there will be two options available to such creditor. The first option is to take the insolvency judgment to DAFC and try to enforce this judgment against a DAFC entity, so-called DAFC entity or company registered in DAFC. Or the second option would be just to try and start the insolvency of a recognized foreign company itself. But speaking about enforcement, the pinch of salt here would be that there will be very difficult jurisdictional gateways to satisfy. And those will be very, very fact intensive. So you will need to look at particular proceedings and the circumstances around that, because I'll give you some examples as to what these jurisdictional gateways are, so that you have some flavor of what kind of issues will be reviewed by the court in that case. Well, first of all, as the DAFC law says, the foreign proceedings that have been commenced, in our case in Russia, is recognized by DIFC courts as having appropriate laws and procedures for dealing with insolvency. So that will be a first very interesting gateway to satisfy, and it will be a very interesting discussion as to whether DIFC court will view the Russian insolvency laws and procedures as appropriate. And speaking about the case that you mentioned, Nikolai, about insolvency of foreign companies in Russia, I mean, it's not a secret that there's no procedure for that type of insolvency in the law. This is something that was invented by the Russian Supreme Court in one of its judgments. So the big question will be if a creditor will bring this type of a judgment, introducing so-called non-main or the secondary insolvency proceedings against foreign company in DAFC. There will be a big question how this gateway will be satisfied, because, you know, I do respect judgments of Russian Supreme Court a lot, but they are not a part of a Russian insolvency law. The second gateway that would need to be satisfied is that these foreign proceedings, in our case the Russian proceedings, are consistent with the principle of natural justice and must not be contrary to the public law in DIFC. We have discussed that already. Another interesting principle that will need to be satisfied, and another gateway, will be the following: the foreign proceedings should not discriminate against creditors on the grounds of their nationality or the place of residence. Speaking about current state in the Russian insolvency proceedings, where you have creditors from friendly jurisdictions and non-friendly jurisdictions, where non-friendly creditors get all their money to blocked accounts just because they come from a wrong place, from Austria, for example. How would that satisfy this gateway? So there will be a lot of interesting questions to discuss if such matter is brought before a court in DIFC. But as I say, it will be very much fact intensive, and it will very much depend upon the circumstances of a particular case.
Thank you very much, Igor. So let's